You're listening to the Patenting for Inventors podcast, part of the Look Legal Pods from the law firm of Nolan Hyman, the #1 source for your intellectual property, business, and entertainment law needs. Now here's your host, registered patent attorney, Adam Diament.
Hello and welcome to the Patenting for Inventors podcast. I'm your host, Adam Diament, a registered patent attorney and partner at the law firm of Nolan Hyman in Los Angeles, California. This episode is Patent Exhaustion, the hidden patent rule triggered by your first customer. So you finally did it. You built your prototype, you got your patent, you got it to market, and you're feeling pretty good about yourself. But then someone asks you this question that sounds simple, but actually isn't. Once you sell your product, do you still own the patent? And the honest answer is sometimes yes, but your rights change in a really specific way that people don't always think about. That change in rights is what is called patent exhaustion. Now, what do I mean by that? The way to think about it is like this. Owning a patent gives you the right to exclude others from making, using, selling, offering for sale, or importing your invention. That's the bundle of rights Congress gave you under 35 U.S.C. Section 154. But the moment you sell a physical embodiment of your invention, a different rule kicks in. It's not that your patent disappears, it's that certain enforcement rights exhaust when you place a product in the stream of commerce. Let's imagine a simple example. You invent a new kind of adjustable wrench that has a feature no one has ever seen before. You get a patent. You manufacture 1,000 of these wrenches and you sell them through your online store. Now, if a competitor starts manufacturing the same wrench, you can sue them for patent infringement. You can prevent that. But if a customer buys one of your wrenches, the patent doesn't give you the right to tell that customer what they can or can't do with your wrench after purchase. That right has been exhausted by the sale. So in patent law, exhaustion means that once you authorize a sale of a patented item, you can't use the patent to control what the buyer does with that item. You can't stop them from reselling it. You can't stop them from using it. You basically lose your exclusionary control over that particular item. Now, you still have patent rights against third parties making new copies of the wrench, but not against someone who bought a legitimate copy from you. That's why when people talk about the first sale doctrine, they're often talking about patent exhaustion. The term first sale is more common in copyright law, but the underlying idea is similar. Once you sell it, you've gotten your reward for that particular copy. You can't extract additional control through your patent. Okay, but here's where it gets interesting, and where inventors sometimes make mistakes. Exhaustion typically applies to authorized sales. So if someone bought your product from a reseller who didn't actually have the right to sell it, for example, they were a counterfeit distributor, that sale might not exhaust your patent rights. But if it were an authorized sale, even if a distributor sold it at a discount or a retailer sold it in a different territory, your patent rights on that item are generally exhausted. And this rule isn't just about domestic sales. The U.S. Supreme Court has held that authorized sales outside the United States can also exhaust U.S. patent rights. So if you sell a product in Germany with your permission, someone could theoretically bring it into the U.S. and the patent wouldn't let you stop them from reselling that same product here. Now, there are exceptions and nuances, and companies sometimes try to put restrictions on exports or imports, but exhaustion is a real force you have to reckon with. But let's step back for a second. Why does this concept even exist? Why does the law say you lose some of your patent rights after you sell something? The simple non-legal way to think about it is fairness. If I buy a hammer from you, do I expect you to come after me because I used it to hang a picture? No. I bought the thing. I own it. I should be able to use it. The patent system doesn't want to turn every use of a bought product into a permission slip. That's not efficient and doesn't make sense in everyday commerce. But then you get into those nerdy corners of the law where people try to put restrictions on how products can be used after sale. For example, sometimes companies will include a notice saying single use only or licensed not sold or cannot be resold. Those kinds of notices might be binding in a contractual relationship if the buyer agrees to them, but they generally do not resurrect patent rights that have been exhausted. Once a product is sold, the patent can't typically be used to enforce post-sale restrictions. That's a subtle but important rule. Exhaustion is about patent rights, not contracts. You can have a contractual restriction that survives, but the patent itself won't enforce it after an authorized sale. Okay, now you might be wondering, well, does this mean every time I sell something, I lose control forever? And the answer is no. You still have your patent rights against others who try to make or sell unauthorized copies. Exhaustion applies to authorized sales of specific items, but it doesn't let a competitor just start making your product. It doesn't mean you lose your monopoly, or if you want to call it monopoly or something else, on making new ones. That's still protected. Let's take another example just to make it stick. Imagine you invent a new kind of coffee brewer and sell it with a replaceable patented filter. Your patent covers both the brewer and the filter design. A coffee shop owner buys one of your brewers. The sale exhausts your patent rights so the coffee shop can use it, resell it, or lease it if they want to. But a competitor can't start building new brewers that embody your patented design and sell them to others. Your patent still stops them from making new copies. Exhaustion only applies to that one item you sold. So yeah, once you've sold the patented product, you don't get to keep strings attached to it. The buyer owns it, and they can do what they want with it. That's the whole idea behind patent exhaustion. You've already had your chance to control the item when you sold it. Trying to control it after the fact just doesn't fly legally. Now, where it starts getting sticky is when companies try to use licensing tricks to sneak around exhaustion. Let's say you sell something, but instead of calling it a sale, you call it a license. That way you might try to argue, oh, this wasn't an actual sale, so exhaustion doesn't apply. Companies sometimes pull that maneuver, and honestly, sometimes it works. Of course, do look at how the transaction is structured. If it looks, smells, and walks like a sale, then yeah, it's probably a sale. You can't just slap a license sticker on it and pretend it's different. And here where it gets really interesting for tech products, think about software. A lot of software is licensed, not sold. That's how companies maintain more control. But if your patented invention involves hardware that's bundled with software, and that hardware is sold, exhaustion could still kick in. If you're trying to say the software license limits what people can do with the hardware, you may have a problem. It's like trying to lock the front door but leaving the back door wide open. Another twist, international sales. You might be thinking, well, I'll just sell it overseas and control what happens in the US. As I talked about, not so fast. If you authorize the sale abroad and someone brings it back here, the courts could still say your U.S. patent rights are exhausted. There used to be more wiggle room here, but now it's a lot tighter. Once you authorize a sale anywhere, game over, at least as far as that particular item goes. Okay, now let's flip this around. What if for the buyer of something patented? This is actually super relevant for inventors who license technology or buy parts. If you're buying a component that is already covered by a patent, you want to make sure it was sold by someone authorized to sell it. If it was, then you probably are in the clear. But if it wasn't, you could be on the hook for patent infringement even if you didn't know. That's a nightmare you don't want to stumble into. And this is where paperwork matters. You've got to check those licenses. Was the seller allowed to make and sell the item? Was the patent holder directly involved, or was this some gray market thing? You don't want to be in a spot where you're unknowingly reselling or modifying something that's accidentally infringing. That's the kind of thing that lands people in expensive lawsuits that feel like they came out of nowhere. And there's one more angle I want to talk about, repair versus reconstruction. You think once you buy something, you can fix it all you want, right? Well, yes, but only to a point. You can repair a patented product, no problem, but if your repair crosses into the line of rebuilding it from scratch, courts might say that's actually making a new product, and that could be infringement. There's no clear line drawn either. It's one of those you know it when you see it things, which makes it kind of risky. Imagine you buy a patented coffee machine, one day it breaks, you replace a part, fine. You replace another, still fine. But eventually you're replacing so many parts, it's basically a new machine. You Frankenstein the thing back to life. And that's when the patent holder might step in and say, hey, now you're infringing. Courts will look at the extent and purpose of your repair. Was it maintenance, or were you rebuilding a whole new unit? That distinction matters more than you might think. And if you're in the business of refurbishing, reselling, or recycling products, that line becomes your tightrope. You need to know where exhaustion ends and infringement begins, because the last thing you want is to accidentally start manufacturing in the eyes of the law when you were just trying to make some fixes. So all right, let's wrap this up with a quick sanity check. If you hold a patent, you don't get to keep controlling your invention once it's sold. You got your patent rights to block people from making, using, or selling without permission. But once you sell something, that individual item, that one's out of your hands. It's like putting a bird in a cage for 20 years, then opening the door. You can't expect it to stay on the porch. It is free. And if you're on the other end of that transaction, if you're buying, modifying or reselling, you've got rights too, but those rights only go so far. You have to make sure you're dealing with authorized sellers, not dancing into any gray zones, and that you're not unintentionally creating new products when you just were trying to keep the old ones running. So whether you're the patent owner or someone working in the field where patents are flying around like confetti, understanding exhaustion is crucial. It tells you where your rights end and where someone else's begin. It keeps you grounded in what you can do and helps you avoid accidentally stepping on legal landmines, because let's face it, nobody wants to get sued for just using something they bought fair and square. That's it for today's episode, and if you need help filing a patent application or other intellectual property, give me a call at 424-281-0162. Until next time, I'm Adam Diament, and keep on inventing.
Thanks for listening to the Patenting for Inventors podcast. If you enjoyed the show, please kindly rate and review on your favorite podcast platform. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information about how we can help with your own legal needs, check out our services at nolanhyman.com. That's NOLANHEIMANN.com. Or call Adam Diament directly at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.